On the 27th of February 1967, the Eastern Caribbean Supreme Court opened its doors as the Superior Court of Record for the Eastern Caribbean. From the British Virgin Islands in the north to Grenada in the south, the court would mark its territory as it began a journey like no other. With such profound heritage, we bask in the recollection of others, reminiscing the fond memories of the early days. Join us as we view the growth and transformation of the ECSC over the last 55 years through 5 unique perspectives.
I qualified in 1957. It was enjoyable. It was lovely. And there we learned from each other as well. We were like a family. And Wednesdays was a day we used to discuss, hear our different opinions, people asking questions for help for this. It was, at that time, I would say the bar was a very strong bar, small but strong.
In 1979, the court would face one of its earliest challenges, briefly losing one of its member states.
I was called to the bar in Grenada in 1984. At that time, we operated under the Supreme Court of Grenada. The court did not revert to the Eastern Caribbean Supreme Court until after what is known as the Trial of the 19.
The court would return to its 9-member state and territory composition to continue its mission to provide access to a system of justice that is fair, efficient, and effective. Throughout its existence, the court has always had a cadre of outstanding legal jurists whose legacy is etched in our jurisprudence.
When I was appointed first, Sir Lascelles Rotten was the Chief Justice, and Sir Vincent replaced him. When he came on board, he was primarily concerned with jurisprudence. And he often said that one should be immortalized by the quality of one's judgments. So working with him was intense, and there are a lot of critical discussions on legal points. Some of the other judges with whom I served included George Moore, Dr. Nicholas Liverpool, Albert Matthew, Albert Redhead, Satran Singh, all of blessed memory, unfortunately, and the current president of the Caribbean Court of Justice, Adrian Saunders, and Brian Aline.
In the background stands formidable teams of persons working to ensure the smooth operations of the court.
I joined the court in 1980, and my stint lasted until 1984. The court was only 13 years old at the time, so it was pretty young, and there were only about 28 lawyers in private practice, and probably about 15 at the public bar. So the court was very small. There was very good rapport between the attorneys and the court. And the most important point about the registry at that time is that the court process was driven by the parties. At that time, we were not setting matters down. The parties were determining when the matter would be set down. So it was very, very different. The accent now is on professionalism and excellence. I have to say that maybe there's something about courts that brings out the best in staff, the professionalism and the excellence, which is apparent, I think, in all of the registries of the Eastern Caribbean Supreme Court and in the headquarters.
The 1990s would bring with it winds of reform, which blew throughout our island chain jurisdiction, paving the way for a remarkable transformation.
Well, I had the opportunity of traveling, seeing other judiciaries, and I realized that we were pretty under-resourced and afflicted by old-fashioned attitudes and inherited colonial culture. So in order to win the confidence of the public, we had to modernize. We had to change attitudes and try to focus more on fair and just and prompt dispute resolution. And I was very happy that by the end of my tenure, we had already had case management software installed, and the digitization process had begun. And so the courts had to be marched towards a technology-based system had started.
The transformation resonated in many different ways.
The transformation really came from the civil procedure rules. And what transformed it is that it set up how the court should be governed.
To my mind, mediation is one of the best innovations of the new system of jurisprudence. Whereas before you had trial and one party won, one party lost. Mediation encourages parties to seek, by way of compromise, to settle matters to the satisfaction of them both. It has been highly effective in reducing the backlog of matters to be tried, and therefore to reduce the workload on the court.
The biggest change for the registry really was the civil procedure rules that were passed in 2000. They've been amended several times after that. And those rules ostensibly put the registry in charge of the court process. The most important thing is that the registry is now in the driving seat. The Chief Justice has described the registry as the engine room of the court. If the engine is not working, it's not going to move. So it's extremely important that the registry operates at an optimal level to ensure that the process keeps moving fairly quickly.
This transformation continued through the 2000s, with the court marking many notable achievements.
There are a number of developments that the court has implemented since the 50th anniversary, but the most significant, I think, is the implementation of the court's e-litigation portal across the OECS region, which has had a transformative impact on all persons who operate with the court, or customers or stakeholders.
The court didn't suffer during COVID. The Chief Justice passed a practice direction for emergency filings, so people could file by email. They could pay later. As soon as the court reopened, they could pay, and so nothing was held up.
Well, during the last couple of years, I've been absolutely pleased at the way in which all aspects of technology has been embraced.
It's revolutionary what's been happening. The court was on the trajectory from 2000, and we've just been going from strength to strength. It has been absolutely, absolutely wonderful. The court has matured beautifully. The court is recognized as being one that's of a very high standard.
As we move into the next era, there is no doubt that the court is well placed to navigate the future with new goals in sight.
In the next 10 years, I think that the court will transform to one that is truly paperless. There is really no going back on that. And because what we have seen with matters such as natural disasters, now with the pandemic, it demonstrates that what the court has to do is to continue to leverage technology in terms of making access to justice more accessible, more equal to all of the persons in the region and beyond.
Reflecting on the last 55 years, the Eastern Caribbean Supreme Court's remarkable accomplishments bring overwhelming satisfaction.
I think the ability as Chief Justice to implement decisions that are transformative in terms of effecting a very positive impact on the lives of people in terms of the provision of court services, making access to justice more reliable as well as more accessible in that sense. I also gain a sense of satisfaction, I think, from decisions which positively impact on the lives of all people.
And so, we celebrate this outstanding institution which at 55 is steadfastly navigating, redefining, and reimagining the future. Cheers to 55.
I wish the court a happy 55th anniversary.
Happy birthday to the Eastern Caribbean Supreme Court.
And I want to wish the court a happy anniversary.
I wish the Eastern Caribbean Supreme Court a happy 55th anniversary, and as is customary, I wish it many more happy and successful anniversaries.
I take this opportunity to join with others in wishing the Eastern Caribbean Supreme Court happy 55th anniversary, and for many more anniversaries to come.